re-estate of Hannon. So that was the decision of Judge Baker, re-estate of Hannon, and the first is a decision of Miss Justice Costello in the High Court. So I've written a paper which you'll have in your booklets. I think the last page might have got lost in transition, but just contains the conclusion. I'm sure that can be sent on to anyone who's looking for it. To give an overview of my presentation, I'm going to speak about limitation periods in general as they apply to creditors' actions against estates. And what we're talking about here really is bank debts and claims regarding mortgage property. And then I'm going to look at Section 9 of the Civil Liability Act, and in particular whether debts repayable on demand are covered by that section. And then we'll look at some of the case law, to finish with look at Bank of Ireland v Matthews, this most recent decision. And then in the second part of my presentation, I'll look at Hannon and the special circumstances jurisdiction of the court to grant administration in special circumstances under Section 27(4). So just to start with those general limitation periods, I've reproduced the most important ones there on the slide, and as I say, this is limited to the limitation periods that concern creditor actions. So it's 6 years under the statute of limitations 1957 for actions founded on simple contracts, and that includes contracts for debt. And then there are separate limitation periods for actions that arise on foot of mortgagees enforcing their remedies under their security. And those are 12 years to recover land, which includes possession proceedings, the kind of proceedings that you see quite frequently these days in the circuit court, and also actions for the sale of land, where the remedy so is also the sale of land by the mortgagee, or to recover the principal sum of money secured by the mortgage or charge. One thing to be mindful of is the shorter limitation period of 6 years to recover arrears of interest secured by the mortgage or charge. And what I've put there at the bottom of the slide is the effect of the expiry of the limitation period, because that does differ as well. While the remedy is barred in actions founded on contract, but not the right, in actions in rem, those are to recover land that might be bought by a mortgagee, it's the title of the mortgagee that is extinguished, as well as his right to recover the principal and interest secured on the mortgage or charge. So having spoken then about the general limitation periods, these are of course subject to the special limitation periods, that we find in Part 2 of the Civil Liability Act. And I've reproduced on this slide there the two relevant sections in full, because they do sometimes prove problematic to understand for practitioners. So it's Section 8 that sets out that on the death of a person, all causes of action, other than accepted causes of action, subsisting against him, shall survive against his estate. So that sort of changed the common law position prior to the passing of the Act, that some claims against a deceased could not be enforced, while others could, against his representative. And then what Section 9 goes on to say is it provides a special time limit for these causes of action which survive. And subsection 2 there states, no proceedings shall be maintainable in respect of any cause of action which has survived, unless either A, the proceedings are already in being, so they're up and running against the deceased before he dies, and in that case, representative can simply be substituted as defendant. Or alternatively, the proceedings are commenced within 2 years from the date of death, or within the general limitation period, whichever period first expires. So in most cases, the 2-year limitation period will be the one that expires first when this section is applicable. And then turning to what that section means really and how it's been interpreted by the courts. As you'll see, the word that's used in subsection 8 is subsisting. And the courts have interpreted that to mean that this section only applies to causes of action which have already accrued before death, or at the moment of death. And that was particularly relevant in some of the promissory estoppel cases that have been heard by the court. So this quote here by Mr. Justice Fenley in Corrigan v Martin was a promissory estoppel case. So if we know that it's only causes of action that survive against the estate, and those are ones that subsist prior to or at the date of death, and in fact that really relates to whether the cause of action has accrued, the next question is, or when does a cause of action accrue, as in particular in relation to creditor actions. And the answer to that question is when it can first be recovered by legal action, and really it's the earliest point in time at which an action could be brought. So with other kinds of actions, like actions in negligence, it's sometimes kind of easier to sort of ascertain that. But when it comes to actions founded on contract or creditor type actions, that can prove problematic. And in each case, what's important to stress is it's a matter of contractual construction as to when the cause of action accrues. So that means that that will depend on the factual circumstances and, more importantly, the proper interpretation of the terms and conditions of either the loan documentation, the agreement, or the mortgage documentation in each particular case. So in some cases, it'll be fairly straightforward. For example, a term loan, if I make an agreement with my friend and I agree to lend her a sum of money and we agree that she will pay that back at the end of the year, and if at the end of the year comes she hasn't paid me back, I know that from that point my cause of action has accrued and I will either have 6 years to pursue her for the debt or 2 years should she die in the intervening period. But in other cases it's a little bit more complicated, and this is what leads us on to debts repayable on demand. And this is the potential to affect not just loans but also promissory notes and guarantees. And in fact, the first case that I've mentioned there, Bank of Ireland v O'Keefe, which is one of the earliest cases to consider this section, that was a guarantee case. So what we know about that is when looking at loans that are repayable on demand, it is necessary to examine the terms of the agreement in each particular case to ascertain